Hi, I'm Meredith Duncan, and in this module I will provide an overview of the structure and role of the courts throughout the United States. Some of what I will be explaining to you will likely just be a refresher from a U.S. history course or a civics course. However, I'm also hoping that you will learn more than a thing or two from this talk. My goal is to provide you with important and fundamental foundational information as you embark upon your study of law. As you probably recall, the United States government is divided into three separate branches: the executive branch, which is spearheaded by the President of the United States; the legislative branch, comprised of lawmakers such as our U.S. senators and members of the House of Representatives; and the judicial branch, also known as our federal court system. Each branch serves a unique and crucial role in the administration of our government. Very broadly speaking, the executive branch enforces the laws, the legislative branch enacts the laws, and the judicial branch interprets and applies the laws. This division of authority, known as separation of powers, limits government power by apportioning legal authority among the independent branches so that no one branch can exert full federal authority without being held accountable to or relying on the others. This concept is sometimes referred to as the checks and balances system. The United States government as a whole is a federalist system. A federalist system is one that divides power between the national government and state and local governments. This means that the United States government, or the federal government, is supreme in its authority, but it shares its sovereignty with each of the individual 50 states. In fact, our United States Constitution grants all powers not expressly reserved to the federal government to the individual states. As a result, each of the individual 50 states has its own state constitution and its own state court system. Article 3 of the United States Constitution established the U.S. Supreme Court and granted the U.S. Congress the authority to create the lower courts. There are three levels of Article 3 courts in the federal system: district courts, the circuit courts of appeal, of which there are 13, and the United States Supreme Court, the highest court in the American judicial system. These federal courts have exclusive jurisdiction over cases arising under federal law, as well as over disputes involving foreign governments or multiple state governments. And with limited exceptions, state courts have exclusive jurisdiction over everything else. One notable exception is that the United States Supreme Court may review any state's highest court decision that raises a federal constitutional issue. In the event that courts are presented with an issue for which both applicable federal and state laws exist, the federal law is always given precedence. State court systems are often set up similarly to that of the federal government. So whether one is considering the federal or a state court system, there are generally two kinds of courts: courts of original jurisdiction, which are commonly referred to as trial or district courts, and courts of appellate jurisdiction, which are sometimes called courts of appeal. Most of the time, trial courts are the only courts that have the authority to have cases tried before them. These trial courts are similar to what is commonly portrayed on TV or in movies. There's one judge, several lawyers representing their respective parties, and typically a jury whose job it is to determine the facts in the case. After the facts are determined, the judge instructs the jury regarding the applicable law and asks it to make a decision by applying the law to the facts. The decision in a trial court is known as a verdict. For a civil action, a verdict might be, for example, a ruling in favor of the plaintiff for a specific amount of money to be paid by the defendant. In a criminal action, the jury's verdict is typically a declaration that the accused is or is not guilty. Trial courts are to be contrasted with appellate courts. Appellate courts operate much differently than the trial courts I just described. The job of a court of appeal is to review the decision of a trial court or a lower appellate court for errors. These courts are typically comprised of a panel of judges or justices. Appellate courts, sometimes referred to as higher courts, review the lower courts' application of law and, in rare cases, their findings of fact. The federal system and most state systems have two levels of appellate courts: an intermediate appellate court and a higher appellate court, whose job it is to review the decisions of the intermediate court. Accordingly, these appellate courts are sometimes called reviewing courts. The highest appellate court is typically the Supreme Court and has final authority over all matters within its jurisdiction. After an appellate court has reviewed a lower court, the court issues an opinion, which is typically a detailed explanation of its decision regarding the relevant law and, where appropriate, the facts important to reaching its decision. Law school casebooks are chock full of appellate decisions, and law professors love to discuss and dissect them at length in classrooms across America, a subject that Professor McClurg will tackle with you in the video module covering the Socratic and case methods. For purposes of this module, you need to appreciate that whether in a federal or a state court, all courts' powers are limited to deciding cases and controversies over which they have jurisdiction. To say that a court has jurisdiction means that the court has the power to hear and decide the case. One additional item is worth mentioning. Although the federal courts do not, some states divide their court systems along civil and criminal lines. In states that do so, a criminal case works its way through the state's trial and appellate courts that hear only criminal matters, while civil actions work through the state's trial and appellate courts that hear only civil matters. So what distinguishes a criminal matter from a civil matter? Well, very generally speaking, a criminal matter is prosecuted by a government entity on behalf of its citizens against a person or persons who have violated the criminal law. The punishment for violating the criminal law is typically incarceration. This is to be contrasted with a civil action, which is most often brought by private citizens against wrongdoers for harms committed against them individually. Typically, the remedy for a civil action is monetary damages and not incarceration. Incarceration is unique to the criminal law system. New law students arrive expecting the law to be a neat and tidy catalog of rules that they can memorize and clearly understand when the need arises. Unfortunately, that is often not the case. Part of the uncertainty of the law stems from the fact that the United States is primarily based upon a common law legal system. Let me take a moment to explain a common law system. Although most of the rest of the world follows what is known as the civil law tradition, the United States does not. In civil law systems, the law is derived primarily from codes. For example, books of neatly organized statutes promulgated by legislators. In theory, judges in civil law systems have no power to make or create law. Their job merely is to follow the rules set forth in the codes. The civil law system does not really work quite that simply in practice, as all legal language requires interpretation, and courts must do the interpreting, but this is a good enough explanation of a civil law system for now. Contrast a civil law system with our common law system. The common law has its historical roots in English law and is essentially judge-made law, derived from and developed through case precedent or previous case decisions. In a common law system like ours, judges and courts are called upon to create law when it is necessary. As a result, the common law often develops slowly, sometimes on a case-by-case basis. And remember, as I mentioned previously, a court can only make a decision based on the facts before it. So when new facts arise, the difference in facts might lead a court to depart slightly from its previous pronouncement of the law. The result is that the law is ever evolving, the precise contours of which may be difficult to discern. But do not despair. Our courts are not permitted to just make up the law as they see fit from case to case. Rather, the doctrine of stare decisis insists that courts interpret and apply the law in a manner consistent with prior court decisions. The Latin term stare decisis literally means to stand by things decided. Honoring precedent helps maintain stability in the law by offering guidance not only to presiding judges, but also to others seeking to learn and comply with the law. Our common law system is beneficial because it allows courts to respond to new problems arising out of ongoing social and technological change. However, one of the downsides of this common law system is that it can lead to confusion as to what the law actually is when applied to a brand new set of facts, a situation that arises frequently. as there are rarely ever two factual situations that are completely identical. So there you have it, a handy-dandy lesson on the U.S. court system. I hope this has been beneficial to you.